light of the foregoing, we hold that the once general rules of international law in Article 2.5 of the Constitution refer to customary international norms, including jus cogens. There is a general acceptance that customary international law requires, in the words of Article 38(1)(b) of the Statute of International Court of Justice, a general practice accepted as law. That is both sufficiently widespread and consistent practice and what states have accepted as law, opinio juris, accompanying it. Examples of customary international law include the doctrine of non-refoulement of refugees and granting of immunity for visiting ends of states. Since the basic structure doctrine is a constitutional law principle acceptable in just a number of states and not an international law principle, it does not amount to a customary international law principle. Therefore, Article 2.5 of the Constitution cannot be the basis for founding the applicability of the basic structure doctrine. In the end, I find that the basic structure doctrine and the 4 sequential steps for amendment as prescribed by the High Court and the majority of the Court of Appeal are not applicable in Kenya under the Constitution. Any amendment to the Constitution must be carried out in strict conformity with the normative standards and provisions of Chapter 16 of the Constitution. I will now move to the second issue, whether the President can initiate amendments to the Constitution through a popular initiative. The question raised was whether the President could initiate the amendment and popular initiative routes provided for under Article 257 of the Constitution. Like other norm-producing process, a constitution amendment process starts with an initial decision. That is the initiation or activation of the process. The initiative speaks to how the amendment process starts. The story starts with the 8th August 2017 presidential elections, in which the president was declared by IEBC as having been duly re-elected for a second term in office. The election results were challenged before the Supreme Court by Right Honorable Raila Odinga, who had been declared as the runner-up to the presidential elections. The Supreme Court annulled the results through a majority decision delivered on 1st September 2017 and ordered fresh presidential election to be conducted within 60 days of the nullification. However, the Right Honorable Raila Odinga and his political coalition, the National Super Alliance, withdrew from participating in the fresh presidential election, which took place on the 26th October 2017. Subsequently, Right Honorable Raila Odinga and the NASA coalition vowed not to recognize the government that was formed as a result of the fresh presidential election. This led to some incidents of violence. After months of tension, the President and the Right Honorable Raila Odinga, in an act of statesmanship, patriotism, and bipartisan accord, emerged on 9th March 2018 to announce to the public that there was cessation of hostilities between the two political sides in what they called a handshake, through a joint communique, building bridges to a new Kenya. It is in the quest to implement this noble objective of promoting national unity and overcoming other challenges identified in the joint communique that the President appointed the Building Bridges Task Force. On 26 November 2019, the BBI Task Force released their report, which was unveiled to the public. On 10th January 2020, the President appointed the BBI Steering Committee with the terms of reference that were stated therein. As far as the President's actions with respect to setting up the BBI Task Force and BBI Steering Committee to further the agenda of promoting national unity were concerned, in my view, these actions cannot be faulted. Indeed, they are roundable acts of statesmanship executed within the ambit of the provisions of Article 131(2)(c) of the Constitution. This article demands nothing less from the President, as it directs the holder of that venerable office to promote and enhance the unity of the nation. However, it is important to clarify that the legal constitutional question before this court does not go to the propriety of the pursuit of the building bridges to unity project. The question before the court is a narrow one, and it relates to whether a constitutional amendment process initiated by the President can be pursued through a popular initiative route prescribed in Article 257 of the Constitution. To answer the question as to who may initiate an amendment process through a popular initiative requires that we understand the purpose that is intended to be served by introduction of the popular initiative as a route for amending the Constitution. This is pursuant to the purposive interpretation decreed by Article 259 of the Constitution. The Constitution making history that I have highlighted demonstrates that a popular initiative was a tool carved out exclusively as a route for constitutional amendment by citizens. In essence, amending the Constitution through a popular initiative was intended to be a citizen-driven